ongoing judgment in the matter of remand and another, and the Council of the City of Wakefield.
For the reasons contained in the judgment handed down this afternoon, this appeal is dismissed. The appellant shall pay the reasonable costs of the respondent on the appeal assessed at £20,000 to be paid within 14 days. There should be no order as to costs in relation to the intervener.
Yes. My lords, my lady. There were two pieces of housekeeping or updates that I need to provide you with as a result of the adjournment. The first is the pension relief that extended the basic rate limit. It's section 192 of the Finance Act 2004, and one sees it in subsection 4 of that section.
Thank you.
The other question that my lord asked was what were the basic rate limits for the relevant years. Obviously, every year the Finance Act updates the basic rate limit. For the tax year 06-07, it was £33,300, and for 7-8, it was £34,600. My lord, before the adjournment, I was discussing the basic rate limit point, and the argument that my learned friend appeared to be advancing, that the basic rate limit increased by the same amount as the CDR. There's one further observation I'd like to make on that argument, and that is that when one looks at section 6 subsection 2, the section that we're here critically concerned with, one sees that that exists so as to ensure that CDR does not destroy the basic rate limit for the purposes of capital gains tax. If my learned friend was correct, that CDR has the consequence of increasing the basic rate limit, as that term is used in section 4 subsection 4, there would be no need for section 6 subsection 2 at all, because all of the work would be done in 4 subsection 4, where he says the basic rate limit on this new argument is increased by the amount of the deficiency.
Hang on, let me just get that right. It's done by 4.4.
Yes. So 4.4 defines what is the unused part of the basic rate band, and that, as we discussed earlier, is the basic rate limit, or the extent to which the basic rate limit exceeds total income. Now, if my learned friend's new argument is correct, that the basic rate limit is somehow flexible, so it increases by the amount of the deficiency relief, then all of the work that my learned friend says needs to be done is done by subsection 4. There would be no need for section 6 subsection 2, which explains how the deficiency relief is to be taken into account. There'd be no need for that, because on his argument, deficiency relief would have already been taken into account in 4 subsection 4.
You mean it's section 4.4 combined? Well, you need some cross-reference to 539, don't you?
No, because my learned friend's argument that he made today was that the basic rate limit, as defined in section 1 of the income tax, which is
There's somewhere you need. So you mean, I think what you're saying is that section 4.4 combined with section 539 on his argument would be sufficient. You have to have some connection with 539.
You have relief defined, of course, my lord. Apologies.
Lord, I wonder if I can intervene here. I didn't before, but I do accept what my learned friend says, that in making this argument we stepped outside the bounds of what was in our skeleton argument, which addressed the basic rate band and not the basic rate limit. Now, the definition of basic rate limit says what it says. It says it's the amount on which you pay basic rate tax. But I do, on reflection, accept what my learned friend is saying before your lordships get too far into this, that the basic rate limit argument I advanced this morning does go further than not that it needs to, but proves too much in a way, as my learned friend has just accepted. So
It sounds as you're saying you're no longer relying on it.
well, what I'm saying is we're relying on what we say in the skeleton, which is that,
Right.
that the basic rate band is a flexible concept. The basic rate band is what you pay basic rate tax on. The basic rate limit is certainly defined in the way I showed you this morning, Your Lordship this morning, as being the amount of up to which you pay basic rate tax. So the argument is certainly there to be taken, but I accept in the context of these sections, as we have always accepted, that effectively on our assumed case, the top limit is £40,000, which is why we're saying you go negative using CDR in order to extend the basic rate band beyond 40. My learned friend is right that it can't be the case that one can go upwards and push the top end of the basic rate limit up. You have to go down.
My lords and lady, that's a useful clarification, and apologies if I've taken this court down a tangent. But
It's
it was,
entirely my fault.
so
So we can cut short. You made your final point on that.
Yes, sorry, just before you go on, just for my own benefit, and one of the things I've been puzzling over when thinking about this case is just what section 6, subsection 2, why it is there. And can you just tell me in a sentence or two why it is you say section 6, subsection 2 is needed? In other words, what work does it do that is not already done by section 4 by itself?
it ensures that the basic rate band is preserved.
Why is that not already achieved by section 4, subsection 4?
Because subsection 4, so it may be best to look at one of the examples, example 2, in my skeleton arguments, which is at paragraph paragraph 16. So what one sees that section 6, subsection 2 is doing is the line below calculation in italics, the deemed income for the purposes of section 6. So it deems the income to be 15,000. Were it not for section 6, subsection 2, the income would be, as we see at the top, 50,000. So were it not for the deeming provision, the total income that we use in 4 subsection 4 would be 50,000, and of course one would have nothing left of one's basic rate band. What section 6.2 does is deems the total income for the purposes of 4.4, and it deems that to be the income less the amount of CRD that's being used. So, my lord, that is how it preserves the basic rate band. It ensures that an individual doesn't lose their basic rate band whilst calculating their income tax purposes if they have CDR, which is available to them.
That's the other complicated way of doing it. can we just operate? Let's just operate for the moment without regard to 6.2 under 4.
Yes.
So somebody has got, taking your figures in your example 2. So this is a case where the CDR is less. Does it matter whether it's more? CDR here is less than the income.
Yes.
So it's reduced by 539 for income tax purposes. For income tax purposes, is this right? 35 is less than the 40,000.
Yes.
And so you would have had an unused part would have been 5,000. That's right. Is that right so far?
No, the income is 50,000.
The income is yes, but I'm just looking at the way that 4.4 operates.
Yes.
4.3 and 4. 4.3 is if no income. Let's start with 4.3. If no income tax is charged with a higher rate, or the dividend up, then you've got. So this is a case where we're within 4.3. Is that right? Because oh, hang on, no, that's not right.
No, it's not.
So that's not right. So this is a case where there will be more, but you're reducing. But the effect I saw 539. The effect of 539 is to reduce the taxable income. Isn't that right? You take the 35,000 off of the 50,000 to deter under 539. Is that all right?
It reduces the exposure to higher rate.
Yes.
Yes.
But it reduces it to higher rate in two ways. One is it reduces it in any event. The taxable income it reduces. No, they're all saying no to that.
So 539 subsection 1, a deficiency is allowed as a deduction
Yes.
from an individual's total income for a tax year.
Yes, that's what I was looking at.
Yes, indeed. Well, that's what the statute says.
Yes. Right. So maybe it was yes, not no. Right. So there are two stages. First of all, it reduces it, and the second thing that happens is that, for whatever it's worth, is that you don't pay. So you've got, in theory, is that right? You've got £5,000 left below your limit of four. I'm talking about how you would do this, not how the other side would do it. So you've got a £40,000 income tax band, a basic tax band. Your income of 50,000 for the purpose of total taxable income is reduced by 35,000,
Yes.
which leaves you 5,000 left of your, for what it's worth, of your basic tax band.
25,000.
25,000, quite 25,000. 25,000 is your basic tax band. But for income tax purposes, you're not paying tax on the. Well, that then deals with your CDR, because all your CDR is taxed at, as it happens on this example, all your CDR is taxed at the basic rate, and you've got £15,000 left, £25,000 left on your on your income tax basic tax band, right? That's where we are so far. Is this right? Tell me if I'm wrong about all this. I'm trying to work it through. So that deals with 4.3. Then we go to 4.4. The reference in subsection 3 is the unused part of the individual. So you don't need. So there's no part of the capital gains tax which exceeds. So where do you want to that? So you've got gains of 50,000. So you do have gains which exceed the unused part of your basic rate band, right? Right. So the answer there is you do have. So now we get to capital gains tax. Under 4.3, you have 10,000. Is it right? £10,000 gains which exceed the unused part of your
15,000, because we've got a 25,000 left of the unused part.
That's right. And you put that into that.
Yes.
So you've got that into that. That's right. That's 25,000. Sorry, you've got 25,000 there. So that's taken up. So you've got 25,000 excess.
Yes.
So then you go to 4 to see what happens to that. Is that right?
Yes.
And the reference in subsection 3, the unused part of it is a reference to the amount by which the basic rate tax exceeds his total income. And we've dealt with that. So under, if we didn't have 6.2,
Yes.
the effect of all of this, is this right? Is that for capital gains tax purposes, you're paying higher rate tax on that 25,000.
Yes.
So that's what it would be.
Yes.
Now, what does 6.2? How does 6.2 change that? Or what impact does 6.2 have on it? Or does that not work on that example?
6.2 preserves that 25,000 that you are then paying at the basic rate.
So the effect of the 6.2 so we've done the 6.2a bit. Section 445 as if his income for the year was reduced by that amount. When you say it preserves it, I'm just taking up my Lord's point, which is what is it?
Yeah. So
What is it done?
I find this the most puzzling part of the whole case.
But
well,
what
what
it-
Section 6.2 is trying to do.
what it ensures happens is that if you have deficiency relief and basic rates, as everyone has basic rates, but if you also have deficiency relief, then for income tax purposes you are maximising the use of the deficiency relief, and you are, I've used the word preserving, retaining that part of the basic rate band that you didn't need to use for income tax purposes because you could use your deficiency relief.
And does it amount to more than just saying the basic rate band for income tax purposes, to the extent it's unused, is treated as transferable to capital gains tax?
That's precisely what it is doing.
Why does that?
Why is that not done by 4.4?
Yeah, why is it? Why is that not done by 4.4? I thought that's where we'd got to without even looking at 6.2. Somebody wants to hand you something, either to help or to give you. Not sure which.
So, it makes sense, and it's what I've been trying to explain quite clearly. 6.4 is the
So in our example, because of the tax relief deduction in 539, in our example, the capital gains tax exceeds the unused part of his basic rate. So, in 4.4, the amount by which the basic rate limit exceeds total income. There is an excess in our example. There is an excess because your 50,000 your 50,000 has been reduced to 15,000. and therefore, for income tax purposes, and therefore you've got 25,000
So what,
excess.
your income tax hasn't been, in 4.4, hasn't been reduced. It's still 50.
Why? In 4.4y, the unused public is the amount by which the basic rate limit exceeds his total income as reduced.
But sorry, that's the point that my learned friend said in his opening. Everyone accepts that those reductions are not CDR
Ah, why is
because those concern
Just general relief.
they're general relief that lower the income, as opposed to CDR, which only operates for the purposes of extra liability for higher rate.
This is hyper confusing because section 6.2 begins by telling you exactly the contrary. It says it's to be a deduction of an amount from your total income. I know you didn't have to go to subsection 3, but on the face of it, it looks exactly like something that would feed into 4.4.
But subsection, this is only for the purposes of extra liability, as we see in 2A.
Yeah, well, all right. And I was saying,
So that
we'll
it-
have to read
I-
those two together, but it is a very, on the face of it, the 2A looks exactly like a deduction from total income, doesn't it?
But it's not, because it's only for the purposes of
Versus a higher rate.
higher rate.
So the whole point of 6.2 is for, as it was, is to switch off that narrow deeming
Yes.
and tell you to treat it as a deduction like any other. Is that? Oh, well, one head behind you is nodding and the other is
No, I don't.
the opposite.
It doesn't quite go that far.
So why doesn't 5393 make it operate as a deduction for calculating total tax?
Because of subsection 3. Subsection 1 only applies for the purposes of determining the individual extra liability. My lords and ladies, I'm sorry to cause confusion. It is accepted by both parties that part in parenthesis in sub 4 doesn't apply.
But we need to know why. That's what I'm telling us.
And the reason is because that is referring to reductions to income as a whole. What it's not referring to is here where we have a relief that is only for certain types of income, i.e. the higher band.
So, so 4.4 in parentheses is only referring to reductions from income as a whole, not to CDR, e.g. CDR, which is relevant to determining extra liability.
Yes.
So it's not in that sense a genuine deduction or reduction.
No, indeed.
Mr. Pritchard, I don't want to muddy matters any further at all, but the explanation you were just about to give to the court, have you now given it when
Yes.
you had conferred with those behind you?
I think it was going to be a reiteration of what I'd said previously, but the important clarification is those words in parentheses
Yes.
don't apply.
Right.
I'm being told they think we're there now behind me. So.
And that's common ground.
Yes. One may be forgiven for finding it quite difficult to get a grip on at first, or indeed second flush.
Anyway, there we are.
Anyway,
So, and the effect, you say, of 6.2 is you say is to treat that as a deduction, as if the income were reduced by that amount.
By that amount.
So that then says, all right, although it's technically only used CDR for the purposes of calculating higher rate tax or extra liability, it's called, for this purpose, for CGT purposes, you are to treat it as a deduction.
Yes.
Okay, right, I think we've got that.
My lord, if I could focus on subsection 4 of section 4.
Yes.
the wording there is the basic rate limit exceeds his total income. My learned friend has helpfully explained that it's accepted that for today's purposes 40,000, for example, would be the basic rate limit. Parliament has asked the question, well, how much does that exceed total income? In answer to the question, what did Parliament have in mind when it was referring to total income? We say that plainly it had in mind an income that is 0 or above. That is the common ordinary meaning of the word income. A negative income isn't income at all, it's outgoings. Turning then to section 6, subsection 2. This says that where for any year of assessment by virtue of section 539 a deduction of amount is made for the purposes from person's total income for the purpose of extra liability, section 44 shall have effect as if his income for the year were reduced by that amount. We made two observations here. The first is the reference to by that amount, and I've already addressed you this morning on why we say that is important. We say it relates to the deduction of an amount is made in the paragraphs before. The second observation is the use of the word reduced. We do say that's important because Parliament, we submit, intended by the use of the word reduced that someone can reduce a number to make it smaller until one gets to the point that there is nothing further to reduce, i.e. until one gets to the point of 0 or nil. The upper tribunal at paragraph 60 of their judgment referred to the explanatory notes of section 25 of the Income Tax Act.
Which paragraph?
It's paragraph 60. It's on tribunal bundle page 82.
Yes.
And the paragraph 60, having at 59 addressed the language in subsection 6, so 6 subsection 2, the tribunal then had regard to section 25(4) of the Income Tax Act 2007, which expressly provides that a relief or allowance may be deducted at step 2 or 3 only so far as there is sufficient income from which to deduct it. And then the tribunal said that simply makes explicit what Mr. Furness accepted was the general position anyway, as the explanatory notes say. And they say some, but not all of the source provisions contain the rule that income cannot be reduced below nil, but even when not explicitly mentioned, it has always been the accepted practice that a deduction can only be made from income to the extent that there is income to absorb the deduction. The position is now explicit for all income deductions. My learned friend took you very briefly to the historic legislative provisions. I won't take you to them, just merely to rebut one submission my learned friend said, and that was that in the 1988 provisions, everything was put in one place. That's not correct. One had the same structure that one sees in these later provisions, whereby we have the income tax, corporation tax and capital gains tax provisions, which set out the equivalent of section 4 and section 6, but then quite separate, in a separate act, the Income and Corporation Taxes Act, one has the deficiency relief. Sorry, may I correct myself? In the equivalent of section 4 and section 6 is in the Finance Act 1988. The deficiency relief one finds in the relevant Income Act, which is the Income and Corporate Taxes Act 1988. So it's not right that all of these provisions initially were in the same act. The deficiency relief was always part of an income tax focusing act. Next, my learned friend took you to the updated, or the legislation that's applicable in the second tax year. Section 4, I won't repeat, but the submissions that I made this morning apply equally. We submit to Section 4 in that Act. Section 6, subsection 2 in that Act has changed. It's in the authorities bundle behind tab 5 in the up tribunal decision.
So section 4, your comment on section 4 of the Taxation Capital Gains Act apply equally
Yes.
to ITA 2007.
Yes. The wording is materially the same.
I think it's paragraph 54, isn't it?
Thank you, my lady.
Section 6.2.
Yes, I've got it in paragraph 49.
49.
Sorry, my lady, it's page 76.
What is your submission?
So the submission on 6.2 is that the language has now changed, and we see in the rider it says subsection 4.4 shall have effect as if the person's step 3 income for the year were reduced by the amount of the deficiency. First, we rely on, again, the word reduce. One can only see one's income, we say, step 3 income. One can only see it reduced to nil. One doesn't reduce step 3 income to a negative figure. It then says by the amount of the deficiency, and that is different language to that had been used in the earlier Act, but we rely on the upper tribunal's reasoning at paragraph 62 and 63. And at line 28 of 62, the upper tribunal said the words "the amount of the deficiency" in the concluding words of 6.2 must, we think, refer back to the words in 6.2a, which refer to the taxpayer being entitled to relief by reference to the amount of a deficiency. Suppose a case in which a taxpayer has income of 100,000, CDR of 150. This entitles the taxpayer to relief by way of an income tax reduction under 539. The calculation set out in steps 1 to 6 of 5395 show that the only amount of CDR which can be used for that purposes is 100,000, because the way the relief is given to the attributed is by attributing the taxpayer's income to successive slices as deficiency. And then at 63, in these circumstances, it seems to us to be a possible interpretation of 6.2a that the reference to the amount of a deficiency is not a reference to the whole of the CDR available to the taxpayer, but so much of the deficiency as is the amount by reference to which relief is given, which will necessarily be limited to the amount of the taxpayer's income. So that interpretation boils down to the same point that I was making in relation to the earlier tax year, that the amount that can be reduced under 6.2 is capped, is limited by the amount of income one has to reduce by. So we submit that is the proper interpretation of 6.2. And I note that my learned friend accepts that whatever the tax outcome is for the earlier tax year should be the same for the later tax year. And 6.2 in the later tax year is not an admissible aid to interpretation of the earlier tax year because it comes later. So we submit one starts by interpreting the earlier tax year, and then given my learned friend's concession, one then is looking to have a similar outcome for the later tax year.
I mean, in fact, if it were a different outcome, something would have gone wrong, presumably, with the updating, which was only intended to give effect to the tax law rewrite principles,
Indeed.
and perhaps a few minor changes at the fringes, but certainly not to change points of substance inadvertently.
Indeed, my lord. If I may now turn and dealing with them briefly, because I've addressed them all in my skeleton and we've covered a lot of ground already, to the 6 specific grounds that my learned friend has referred to. The first is his criticism as to the upper tribunal's categorisation of the general purpose of the tax legislation as a general aim.
So we're now going back to the grounds of appeal.
And one sees that at paragraph 34 of the skeleton.
You're going to use the skeleton. Is there any reason why you're using his skeleton rather than just the grounds of appeal, which are much shorter?
My lord, I'm just using the skeleton because I've addressed the arguments that he's raising in the skeleton.
You're going to go to all the arguments, are you now?
I'm going to refer you to my skeleton on as many arguments as I can, my lord.
Grounds of right. Purpose of the legislation. Yes.
What my learned friend took you to a section of the upper tribunal decision where they were addressing the purpose of the legislation, but one really sees what the upper tribunal thought regarding the purpose of the legislation in paragraph 71 of their decision. Paragraph 71 on page 85 in the hearing bundle.
What is your submission?
My lord, so we agree and adopt what the upper tribunal here say, where they say in the third line down, the general purpose of the legislation in section 98 to 103 is not in doubt. It was to assimilate or unify the rate of tax charged on income and chargeable gains. But that cannot answer the specific question that arises in this appeal, which is whether CDR is available to reduce the tax rate payable on chargeable gains, even if the available CDR exceeds the taxpayer's income. So, my learned friend is correct to identify as a purpose the unification of rates, but that doesn't tell us anything about the question that the court here in the upper tribunal and the first tier tribunal had to determine, which is what was the meaning of CDR.
Okay, thank you.
My learned friend relied in his submissions on the UBS case. I've addressed that in my skeleton in paragraph 21. We submit that it doesn't assist the court in any meaningful sense in this case, save that it sets out the general principle regarding statutory interpretation. Obviously, UBS is a case that was concerned with how a court should construe contrived structures. That's not what this case is about. Rather, this case is about interpreting the words of Parliament in the Act. Paragraph 40 of his skeleton arguments. The appellant says that until 2012, HMRC thought that the taxpayer's construction was the correct construction of the words in section 6.2. This is paragraph 40 on page 24. That's not correct, and that is addressed in my skeleton argument of paragraph 23.
Well, even if it were correct, it wouldn't matter.
It
There's no
would.
question of a public law remedy of a breach of a legitimate expectation that that would be thrown out at an early stage.
Yes. At paragraph 41, the appellant argues that its construction must be correct because it is the only interpretation that it gives full effect to the purpose of taxing the next marginal slice of taxable income or gains at the rate irrespective of whether it is income or gains. Now we submit that this sentence is particularly revealing because this appears to be the first time that my learned friend is putting forward the actual purpose that he relies upon, which is said to be the purpose of taxing the next marginal slice of taxable income or gains at the same rate, irrespective of whether it is income or gains. So that's the purpose he's alighted upon, but there is no provisions in which one can derive that purpose. The purpose that one can derive from the Acts are that capital gains, the rate of tax for capital gains is to be the same rate of tax for income. There is nothing in the legislation that says the purpose is to tax the next marginal slice of taxable income or gains at the same rate. And I do observe that at paragraph 39, my learned friend said that the upper tribunal had correctly identified the purpose. But there he said the purpose they had correctly identified was unifying the rate of income tax and capital gains tax. But that is different, we submit, than saying that the next marginal slice of taxable income or gains will be the same. And they won't be, because one has different reliefs, different deductions that apply to capital gains.
He didn't repeat that in his oral submissions today.
What, pardon, my lord?
He was relying on the same points in 39, unifying the rates of income tax.
Yes, but that only takes him so far.
No, all I'm saying is I don't think Mr. Ferguson used the language in 41 last sentence.
My lord, if he didn't, then so good us, because all we say is the purpose is to unify the rates. One can take it no further forward. The second ground is the complaint that the limiting a deduction from income to the amount of income. In effect, it's the negative income points, and I've addressed you on that, my lord. At paragraph 45 of his skeleton, paragraph 45, 5 lines down, my learned friend says that, well, 3 lines down, the question in the present case is whether this specific legislation recognises and gives effect to a deduction which exceeds the amount of total income. If it does recognise and give effect to the deduction, it does so unusually by means of an adjustment to the rate of tax on capital gains rather than by way of an income tax relief. We note his reference there to unusually. The outcome he is seeking is a very unusual outcome. It is converting what is an income tax relief into a capital gains tax relief. If that was the intention of the draftsman, then one would have expected to have seen that set out explicitly. Turning to ground 3, which one finds at paragraph 47. By ground 3, the appellant argues that the upper tribunal's logic derives section 4 of any effect. He refers in paragraph he refers in paragraph 48 to section 6.4. If one sees that the last sentence, it says, and not pursued by further by HMRC because it would deprive TCGA section 6.4 of any effect. Now I understand that to be a typo, and it should be 4.4. We submit that that is not correct, as I've tried to explain to the courts. The purpose of 4.4 is to preserve the basic rate band for the purposes of capital gains tax. That is the effect of the statutory provisions, it's not correct to say they are deprived of any effect whatsoever. And that is the effect that the upper tribunal identified at paragraph 35 of their decisions, and we support that. Whilst undoubtedly that's not the effect that the appellant wants the provisions to have, it is an effect, and we submit it's the effect that Parliament intended.
Can I just go back? Just that I want to understand the point that you made before. Under ground 2, you refer to paragraph 45. There they say the question in the present case whether this specific legislation recognises and gives effect to a deduction which exceeds the amount of total income. That is the question.
Yes.
If it does recognise and give effect to deduction, it does so unusually. I see. You mean he's accepting?
He's accepting that the outcome he seeks is an unusual outcome, and it's unusual because it converts an income tax relief into a capital gains tax relief. It's not the same as, for example, loss relief, where you may have some relief from income tax that you can hold for future years, or you can deduct from future years.
Thank you. Then we're up to which one?
I've dealt with ground 3, so ground 4. This is at paragraph 49. The appellant argues that the basic rate band has no ordinary meaning in the sense referred to by the upper tribunal. We disagree. The upper tribunal was quite entitled to consider, indeed had to consider, what was the ordinary meaning of the words that were being used. And it came to the decision that the basic rate band had the ordinary meaning that they said it did. So in circumstances with a basic rate limit of 40k, the basic rate band is 0 to 40. It came to that conclusion by reference to ordinary and orthodox statutory construction. And we do here rely on the fact that the upper tribunal and indeed the First Tier Tribunal are specialist tax tribunals, and we submit, are in an excellent position to determine the natural and ordinary meaning of tax specialist phrases such as basic rate band. And the upper tribunal address their reasoning on that at paragraphs 36 and 37 for your note. In those paragraphs, they refer to the fact that leading counsel in submissions accepted the basic rate band had an ordinary colloquial meaning. And in fact, if one looks at my learned friend's skeleton, one sees that ordinary colloquial meaning in action. So looking at example 3 that my learned friend has set out at page 17 of the bundle in his skeleton. Example 3, and he says using a hypothetical base rate band of 40,000, and then under the stage 2 he said gains charged at basic rates, in brackets the amount of the basic rate band still available is computed by subtracting from it, i.e. the basic rate band, total income as reduced by CDR. So it's the same colloquial meaning that the upper tribunal found.
We had this exchange between you. It's slightly confused, this issue now, because Mr. Furness made some submissions this morning. He seems to have retracted slightly on them. But what I do understand Mr. Furness to be saying is that in 4.4, the basic rate band is up to 40,000.
Yes.
Accept that.
Well,
It has an upper limit, but no lower limits, I think.
Yes, my lord. We say the basic rate band is the difference between, if necessary, a negative amount of income and 40,000.
And 40,000, exactly. So,
Yes, so my lord, the basic rate band on my learned friend submissions doesn't have an upper limit, because it's the difference between 40,000 and a very negative figure. So the basic rate band, yes, my learned friend will no doubt correct me if I'm wrong.
Upper limit of 40,000, but no lower limit, that's what he says, and you say that means in reality there's no upper limit.
Yes. In my skeleton, paragraph 33, I've referred the court to the Pendragon case where Lord Carnworth addressed the specialist nature of the upper tribunal.
Sorry, where are we now?
This is still under ground 4 basic rate band, and it's the fact that the upper tribunal found that basic rate band had an ordinary and colloquial
I
meaning.
saw that. You have 36 and 37, yeah. And then you were saying something else?
And I was referring to the Pendragon case, where Lord Carnworth, and I'll take you to it, my lord, in the authorities bundle behind tab 17. Paragraphs 48 and 49 of the Pendragon case. Lord Carnworth noted that the upper tribunal is itself a specialist tribunal with the function of ensuring that first tier tribunals adopt a consistent approach to the determination of questions of principle which arise under the particular statutory scheme in question. And then at 49, he quotes what he said in the Jones case. He said, where, as here, the interpretation and application of a specialised statutory scheme has been entrusted by Parliament to the new tribunal system, an important function of the upper tribunal is to develop structured guidance on the use of expressions which are central to the scheme, and so as to reduce the risk of inconsistent results by different panels at the first tier level. So, my lord, we invite this court to show considerable deference and respect to the upper tribunal's view as a specialist tax tribunal as to the ordinary and colloquial meaning of the phrase basic rate band. And then in my skeleton argument at paragraph 33, I have set out various sources where one sees the phrase basic rate band being used in exactly the same manner in which the upper tribunal use it. There's a number of cases that I refer to there, speeches from Parliament, guidance, and even a OED definition. But my lord, I don't intend to take you through each of them in turn. Moving then to ground 5. At ground 5, the appellant argues that identifying the basic rate band meant that the amount of income upon which a person would pay basic rate rather than the amount of income upon which the taxpayer happens to pay basic rate of tax was wrong. This is addressed in my skeleton in full in 36 to 38. Paragraph 50 is the provision of section 1 of ICTA, which my learned friend has taken you to regarding basic rate limit. I observe that section 1 of ICTA defines basic rate limit. It says nothing about basic rate band. We submit section 1 of ICTA just doesn't help. It's addressing a completely different question. And then finally,
What he said in his skeleton is the base rate band is the amount of income upon which a person will pay basic rate tax. That was the submission. And then there's a reference to section 1 of ICTA. You're saying that section 1.3, which he relies on, is talking about the basic rate limit, not the basic rate band.
indeed, and for all the reasons I mentioned just after the lunch adjournment, deficiency relief is not relevant to the basic rate limit, and my learned friend now seems to accept that.
You say CDR not relevant to the basic rate limit.
In the examples we've been using, basic rate limit is 40,000. That's the figure. It's not impacted by the CDR.
You say that's agreed as an upper limit.
It's now agreed, yes.
Okay.
And then finally, paragraph 55, my learned friend says that for completeness, his arguments apply equally to the second tax year. Now, obviously, we say our arguments apply equally to the second tax year as well, and we rely on the reasoning of the upper tribunal and the first tier tribunal in that regard. My lords and lady, I have cantered through my submissions, given that we discussed most of the key issues before I'd got to the specific parts of dealing with the submissions. Unless there's anything I can seek to assist.
That's extremely kind. Very, very well. Thank you very much indeed, Mr. Pritchard. Is that any reply, Mr. Finnis?
A few points, my lord. First of all, to return to the question which the court posed right at the outset this morning, which I lamentably failed to answer, which was how it was possible to generate such large gains, or indeed such large losses, from life policies. And I couldn't precisely call to mind the ins and outs of legislation as explored in the Mays case. But essentially, the reason you can generate large gains is that if you part dispose of a policy, I mean dispose of almost all of it if you like, say within 3 years of acquiring it, the statute allows you a deduction in computing your gain of 5% of what you put in for each complete year. So if you put £1 million into your policy, and then after 3 years you cash in £900,000 of it, you will be allowed as a deduction 75,000, 150,000 pounds. So you've made a huge gain because the statute only allows you to deduct 5% of the initial value of the policy for each year you've held it. The idea being, after 20, it's really to encourage you to hold it for the long term. After 20 years, if you dispose of it, then you get a credit for the whole 100%. But it means if you dispose of it in the early years, you can generate artificially very large profits. And similarly, once you've done that, if you then dispose of the rump of the policy in a following year, when you dispose of the whole of the policy, you then get to bring into account all of the rest of the value. So the other 850,000 pounds in my example would then be available with a view to computing the gain or loss on the disposal of the final 100,000, and that generates a substantial loss. Now, I mean, this is very rough and ready, but
I think that's broadly right. I mean,
yes.
Mr.
Shirley tells me I'm broadly right. I think the court merely needs to be, I hope, needs to be broadly right. I mean, it's obviously.
I mean, this was the magic that was taken advantage of in the Mays case.
Exactly.
Yeah.
Yeah.
I've got it right.
Yeah.
So you generated these enormous gains at the stage when they were realised offshore and therefore didn't come into charge. And then when the policy was finally redeemed or matured or whatever, the onshore taxpayer found he had a delightfully large loss.
That was in essence the way it worked. Yeah. Yeah.
Yes.
Sorry? No. I mean, it needs to be borne in mind, however, that these policies are owned by real people and are not always disposed of and acquired for tax avoidance purposes. Certainly before the financial crash, they were quite widely sold by a number of banks as investment vehicles because they do offer some tax advantages when you make these partial withdrawals, if you do them carefully. So you can have a situation in which an individual will have made, perhaps inadvertently, as sometimes happens, because a very large gain in 1 year, which he has actually to pay tax on. And then in a later year, he disposes of the rest of the policy and makes a very large loss. And the injustice of the way the system worked for people who weren't using it for tax avoidance purposes was that it could generate very large losses, which if you didn't have a lot of income, were simply wasted. You couldn't use them on anything else. So it is a virtue of the unification of tax rates through income tax and capital gains tax that you can, in those circumstances, use whatever part of the CDR that you can't set off against your own income against your gains. It does at least give you some other means of using the relief. So one needs, if one is looking at the broad merits of the two rival constructions here, while this is a case where, as it happens, the CDR is a product of actually the loss and the gain sort of cancel each other out. That will not necessarily be the case, and there will be taxpayers out there potentially who could make substantial losses, who would really value the ability to, in a subsequent year, to use those losses against capital gains.
But am I right in thinking, therefore, that if you're an investor, you're really doing this to generate the tax losses?
No, I mean, not so much now as in the past, but people would genuinely hold these assets as investment products, because there is the ability, if you cash them in on a small scale basis year by year, of getting a favourable tax treatment, and that's entirely intended by the legislation. So they're perfectly genuine investment products. They have been used in avoidance schemes, but equally they have been used. They have in the past, as came out in the Mays case. There have been unfortunate examples where individuals, particularly after the financial crash, made part disposals of their policies instead of disposing of all of some and none of the others, and ended up triggering enormous gains which were duly taxed by HMRC, which bore no relationship to the actual profits or losses that they'd made on the policies. So there is the possibility of individual taxpayers making real losses here, and therefore the possibility that they would want the benefit of being able to use those real losses against their capital gains. Malone Jr. reminds me of the Lobler case, which gives an explanation of all of the background to this. Does appear behind tab 16 of the authorities bundle, if your lordships want to do some further reading on that.
Right. Okay.
Anyway, so that by way of introduction. Also, by way of introduction, your lordships were struggling, if I may respectfully say so, and understandably so, with the wording of section 549 and why it was in the form it was, because it talks about a deduction from total income, even though it's only giving a relief.
Yes.
I don't know whether this really makes life easier, but there is some explanation for why the wording is the way it is. If you go back to the original legislation, or the original form of, well, it's not actually the original form, but the 1988 form of the deficiency relief provision, which is behind tab 2 of the authorities bundle, section 549. Now, what section 549 says, it's very similarly worded to 539 at the outset, but after A and B it says a corresponding deficiency occurring at the end of the final year shall be allowable as a deduction from his total income for that year of assessment, so far as it does not exceed the total amount treated as a gain by virtue of those earlier provisions. So that's similar, but then 2 says, except where the deficiency mentioned in subsection 1 above occurs in connection with a contract for a life annuity made after 26th March 1974, the deduction allowable under that subsection shall be made only for the purpose of ascertaining the individual's excess liability. So in the original form of the legislation, there were two forms of relief. For post-1974 life annuities, you got a complete deduction from your income. And for all other forms of life policy, you got what we now know as CDR, which simply affects the rate of tax. So that goes some way to explain that. Now, what then happens is, by the time of the rewrite, the rules on post-1974 life annuity policies are somewhere else, and so this section now reads rather oddly because it still says that you get a deduction from your total income. But in fact, the only reason for that deduction now is for determining extra liability. But that may just assist to explain why the section takes the rather odd form that it does. It was because originally it was doing two jobs rather than one. Now, coming on to the points that I just need to respond to in the learned friend's submission. The first point that he developed was the fact that, as he submitted, that in order to make any deduction at all in respect of CDR, you needed to have some income which was subject to higher rate tax, and he referred to the 2007-8 version of section 549. If we look first of all at the 2006-7 version, which is behind tab 4 of the authorities bundle, in fact there is no requirement here that you have any particular amount of income in order to qualify for for relief. My learned friend showed you this briefly, but although there is a reference to being liable to income tax, it's based on a hypothesis. So 549 says a deficiency from a policy or contract arising on a chargeable event is allowable as a deduction from an individual's total income for a tax year if, had the gain arisen instead on that event, the individual would have been liable to income tax on the gain. So there, you're hypothesizing a gain, and as long as you would have been liable for tax on the gain, then you get the relief.
So I think what that comes to is it's not a real gain, it's a hypothetical gain. Is that the point?
Well,
You don't need a real
it's a chargeable event gain. It's real in the sense you have to pay tax on it.
You said the whole point of quoting is you're saying there's no requirement for actual income.
There's no. I mean, the requirement for getting the relief for the deficiency is that if you had made a gain, you would have paid tax on it.
Yes.
So, in other words, you have to show you would have been within the tax net. But that's the only qualification. You don't actually need to have any income in the year in which you make the gain. Now, the later version of 539, which my learned friend based his argument on, is behind tab 6, just before last page, just before tab 7. And 5391B there does say, and this is something new. This wording doesn't appear in the older version. That it's a condition of the section applying that the individual would be liable to income tax or would be liable to income tax at the higher rate or the dividend upper rate, or both for the tax year. So at this stage there is a provision which seemingly is introduced that in order to get the relief you have to actually be paying the tax. But that produces a very odd result. This is not, I think, an argument which was developed, well, it certainly wasn't an argument that was developed below. Because if you take that literally, it means that if you have £41,000 worth of income, then you can use your CDR to deduct, even on the revenues argument, to give you some basic rate tax relief against your capital gains. If you have £39,000 of income, you can't, even though you might still, the relief might still be of value. That seems a very odd result to us. It's not a result which is at all mandated by the earlier legislation. And if one took this literally, then, as your Lordship observed a moment ago, something would have gone wrong with the rewrite, because perhaps unintentionally the conditions for getting the relief have changed. So we would say that the capital gains tax legislation has to be approached on the basis that it's not necessary to have income generating higher rate tax in order to access the relief, because that would be a very odd and unprincipled restriction. So that then brings us to the general thrust of my learned friend's submissions, and your Lordships, we have been over this ground already quite extensively, so I'll take this briefly. But the basic issue at the heart of this is why the sum in 4.4 cannot be negative. If you're reducing it by the amount you're told to reduce it by, why can you not produce a negative figure and therefore have the benefit of your corresponding deficiency relief, the whole of it, for your capital gains tax? Now, my learned friend says, well, the purpose of the legislation is actually not to allow corresponding deficiency relief at all. It's somehow to preserve the nil rate band. That we find quite hard to follow, because ex hypothesi in these situations, your nil rate band for income tax, sorry, base rate band, beg your pardon, your base rate band for income tax has been used up. And what is being created by Section 4 and Section 6 is a new relief, which is, we say, effectively generated by the availability of corresponding deficiency relief in order to give some relief to capital gains tax. It's only because CDR exists and because Section 6.2 allows it to be allows income to be reduced by the amount of that deficiency that you get any relief at all. So I do maintain the position that I started with, which is that the effect of this legislation is that it does actually give relief for CGT in respect of a corresponding deficiency relief. And once you've taken that step, then, as I've suggested, it becomes rather artificial to say, well, somehow there has to be a cut-off point because you cannot have negative income. The whole point about 4.4 is that it's not about income at all. It is a computational provision in which you are asked to reduce a figure which represents total income or stage 3 income by an amount which is not otherwise going to be deducted in the income tax context, but is specifically required to be used to reduce that income in the capital gains tax context. So why should one get, as it were, hung up by the idea that in the income tax context it is meaningless to say you have negative total income, when this is a computational device for giving relief from tax in relation to a different tax arrangement altogether?
Could you just repeat that last sentence? Could you just repeat what you just said? Could you just repeat that again?
What I was saying was that one shouldn't get hung up with the idea that you can't have negative total income or negative stage 3 income for income tax purposes. That may be the case for income tax, but here the concept of total income or stage 3 income is being used in Section 4 as a basis for determining the amount of relief that you're going to get from capital gains tax. And there's no reason why one should carry across income tax restrictions.
No reason to carry across limitations.
Limitations from income tax
Income tax.
into the chargeable gains or capital gains context, particularly because, and this is where I started, this is a relief which only reduces the rate. It doesn't reduce the amount of the income. So it's not like you're saying, well, we're reducing your income to something below zero. This is simply a computational device to decide what rate of tax you should be paying on your chargeable gains. Can I just look quickly at my notes and see if there are any other points? I mean, my Lord Justice Henderson did say in the course of engaging with my learned friend that that what was happening here was that the corresponding deficiency relief was being given in respect of chargeable gains, which I think you put it were completely extraneous, you said, to the transaction which generated the loss or the gain. But it's equally possible for CDR to be available against income, which is completely extraneous to the transaction. I mean,
and I suspect that takes the matter no further, because of course the whole point of unifying the rates is that you will get, everyone agrees you will get at least the benefit of any unused lower rate band in relation to gains which have no relation whatever to one's income tax liability.
Or income.
And so this perhaps also addresses the point that the learned friend made in the context of paragraph 60 of the Upper Tribunal decision and the explanatory note on the Income Tax Act, that usually that it was always the case, even before the Income Tax Act 2007 made it clear that you couldn't have negative total income. But in 4.4, we're not undertaking the task of creating negative income. We are undertaking the task of undergoing a computation to determine what rate of tax to pay, not on income, but on capital gains. I think we just join issue on the wording in the 0708 legislation on the amount of the deficiency. We say that that wording means what it says. That what you use to reduce the income is the amount of the deficiency, not that part of it that happens to correspond to the available income. And we simply disagree with the reasoning of the Upper Tribunal in paragraphs 62 and 63 of their decision. I mean, the wording is what it is. And then finally, I think my learned friend's criticism that we're saying that the actual purpose is to tax the next marginal slice. He accepts that you can see a purpose, that the idea is to unify the rates, but he says that we've sort of impermissibly slid from saying the purpose is, not his words, but the sense of what he was saying was that we had moved from saying the purpose is to unify the rates to saying therefore the purpose is that the next slice is taxed at the same marginal rate. We don't see the difference. We see that if you're unifying the rates, then that it must be the case that it matters not what the mix of income and capital is within your overall receipts. Of course, you compute capital gains and income tax in accordance with their own rules. There are two silos of legislation there. But once you put them together to tax them, then it should be the case, if you're unifying the rates, that you pay the same tax on 100,000 at the same rate, whether it's all gain, all income, or half and half. And that's what paying, attaching the next marginal slice is all about. That it means it doesn't matter how the income is income and capital is mixed. In the end, you pay the same unified rate on both. Is there anything else that the court would like to hear from?
Thanks very much.
From our side. Thank you very much indeed. It didn't take us to Mr. Pritchard. And just Mr. Pritchard, you mentioned a new case, which is the Lobler case.
Lobler, yes.
You
I was only mentioning by way of background reading.
And that's what we'll probably do, Mr. Pritchard. But it was the only new, I think, authority that was referred to. As I say, there were no submissions made on it, but we may refer to it. Is there anything you want to say to us about it?
Yes, we would say that the facts of the Lobler case are very different from the facts of this case. This is not, as we understand, the appellant purchased the assets at a loss for the purposes of establishing the deficiency relief. That's very different, as I understand it, to what my learned friend was referring to the Lobler case. I think my learned friend's submission was there may be other people that would benefit from a favourable decision. That may or may not be the case, but that's not this case that one has before us today.
Well, we're very grateful to both counsel and to the juniors for them. They're sitting behind them. We will consider our judgment in this matter in the usual way. When you receive our draft judgments, please make corrections for grammatical and textual errors only. Please agree a form of order. Any further submissions to be in writing. Thank you very much.